Hello, this is our third lecture, which is called Legal Status of the Patient. In the field of legal regulation of healthcare, the patient is the central figure with whom all other subjects, one way or another participating in the organization or direct provision of medical care, interact. In this regard, issues related to the legal status of the patient are especially important in modern medical and legal science. The issues of ensuring and protecting the rights of patients, the regulation of their responsibilities are widely discussed on the pages of scientific publications, in the mass media, on the internet, as well as scientific conferences and seminars. Before proceeding to a detailed consideration of the elements of the patient's legal status, we should give definitions to the basic concepts related to this topic. And first of all, it is necessary to determine who is the patient. According to paragraph 9 of Article 2 of Federal Law number 323 of 21st of November 2011 on the fundamentals of citizens' health protection in the Russian Federation, a patient is an individual who is receiving medical care or who has applied for medical care regardless of whether he has a disease and his condition. The legal status of a patient is the legally established position of the person who has applied for medical care, which includes rights guaranteed by the state as well as responsibilities. It is necessary to distinguish the following types of legal status of the patient. General legal status. It is characteristic of any patient regardless of the disease and the medical institution to which he applied for help. Special legal status of the patient. It is characteristic of certain categories of patients, for example, military personnel, clients of private medical institutions, holders of voluntary medical insurance policies, etc., and persons suffering from certain diseases, for example, tuberculosis, mental illness, AIDS, etc. As a rule, in these cases, it means the availability of certain benefits, the specifics of treatment, the secrecy of information about the disease, the results of treatment, and etc. And individual legal status of the patient. It is characteristic of a particular person, including his rights, freedoms, responsibilities, and legal guarantees of the implementation. This type of the legal status is the most mobile, since its manifestation is fully affected by changes in both the state of human health and other circumstances, for example, age of the patient, duration of the medical insurance contract, urgency in providing medical care, etc. Before we proceed to the consideration of the specific rights and responsibilities of patients, it is necessary to identify those legal sources in which these rights and responsibilities are enshrined. And let's start with international legislation on the legal status of the patient. International legislation in this field is mainly related to such an element of the patient's legal status as his rights. In general, the term patient's rights has been widely used relatively recently, just a few decades ago. This happened when appeals for the humanization of medicine and for occupying the central place in healthcare by the person using its services, in other words, the patient, became popular. Internationally, the human right to health was first recognized in 1948. According to Universal Declaration of Human Rights, everyone has the right to a standard of living, including food, clothing, housing, medical care, and required social services, which is necessary to maintain the health and well-being of himself and his family, etc. Since the second half of the 1970s, a number of important international documents have appeared on the rights of the patient. For example, recommendations of the Council of Europe on the rights of the sick and dying, World Health Organization Assembly Resolution on Health for All, Charter on the Rights of Hospital Patients, Lisbon Declaration on Patient Rights, Amsterdam Declaration on Patient Rights Policy in Europe, and within the framework of the Amsterdam Declaration, the fundamentals of the concept of patient rights in Europe was also published, which declare general human rights in the field of healthcare as well as patient rights. For example, the right to respect for one's own personality, the right to comprehensive information about one's health status, the right to refuse or suspend medical intervention, etc. Most of the legislation on patients' legal status in force in European countries concerns just some particular aspects of patient rights or their manifestations in specific conditions, and they regulate the rights of hospitalized mental patients, for example, persons undergoing sterilization operations, or persons who are object of medical scientific research. General legislation on patients' legal status exists only in the Netherlands and Finland. When we speak about Russian legislation on the legal status of the patient, we should say that in Russia, just as it happens all over the world, the development of medicine and biotechnology leads to the emergence of new problems affecting the legal status of the patient. The need to further deepen and expand is determined by the fact that the mechanism of legal responsibility of medical workers and organizations in specific cases involving harm to the life and health of the patient is currently insufficiently developed. In addition, the expansion of the private sector in healthcare requires the protection of patients' rights in ensuring the quality of medical care provided, and an increase in the scope of paid medical services provided requires strong mechanisms for protecting the rights of consumers of medical services. The general legal status of patient in Russia is based primarily on the relevant provisions of the Constitution, for example, Articles 20, 21, 39, 41, 46, etc. Another document of particular importance regulating the legal status of citizens upon the provision of medical care in Russia is Federal Law number 323. In addition, the laws defining the general status of the patient in the Russian Federation are Federal Law on compulsory medical insurance in the Russian Federation. It defines the status of persons insured in compulsory medical insurance system. The law of the Russian Federation on consumer rights protection. It applies to relations on the provision of medical services to citizens provided by medical organizations within the voluntary medical insurance and compulsory medical insurance systems, and within the framework of contractual relations for the provision of medical services. The patient's status is determined by the relevant norms of civil legislation, precisely Chapter 39 of the Civil Code of the Russian Federation, which is called Paid Provision of Services. Also, we should mention that a large number of subordinate regulations are devoted to the legal status of the patient, among which the following should be noted. Resolution of the government of the Russian Federation on approval of the rules for the provision of paid medical services by medical organizations. Resolution of the government on approval of the rules for the provision of medical care to foreign citizens in the territory of the Russian Federation. Resolution of the government on the program of state guarantees of free medical care to citizens for 2022 and for the planning period for 2023 and 2024. Order of the Ministry of Health and Social Development of the Russian Federation on approval of the list of certain types of medical intervention for which citizens give informed voluntary consent when choosing a physician and a medical organization to receive primary health care. Order of the Ministry of Health and Social Development on approval of the procedure for choosing a medical organization by a citizen when providing him with medical care within the framework of the program of state guarantees of free provision of medical care to citizens. Order of the Ministry of Health of the Russian Federation on approval of the procedure for giving informed voluntary consent to medical intervention and refusal of medical intervention in relation to certain types of medical interventions, forms of informed voluntary consent to medical intervention and forms of refusal of medical intervention. And order of the Ministry of Health on approval of the procedure for familiarizing the patient or his legal representative with medical documentation reflecting the patient's health status. It can be stated that certain steps have been taken in Russia towards legal regulation of the legal status of the patient, and the existing national legislation implementations the norms of international law on ensuring the rights of the patient. As noted earlier, the basis of the legal status of the patient is his rights and responsibilities. And patient's rights are specific rights derived from general civil, economic, social, and cultural human rights and regulated upon receiving medical care and related services or in connection with any medical impact carried out in relation to a person. Speaking about the rights of the patient, it is necessary to distinguish general rights of the patient, the rights of various professional and social categories of patients, and the rights of patients upon the provision of various types of medical care. Speaking about the first group, the general rights of the patients, it is necessary to pay attention to the rights specified in Chapter 4 of Federal Law number 323. These rights are basic, universal, and inherent in all patients. We will discuss this group of rights in more detail later in this lecture. The second group of patients' rights is the rights of various professional and social categories of patients. Here we're talking about the rights of patients who belong to the categories, for example, military personnel or citizens subject to conscription and entering military service under contract, detained persons and persons serving a sentence in the form of restriction of liberty, arrest, taking in custody, or serving a sentence in places of deprivation of liberty or administrative arrest. Rights of minors and pregnant women and mothers. The general rights of the patients in Russia are enshrined in Chapter 4 of Federal Law number 323. These rights include the right to health protection, the right to medical care, informed voluntary consent to medical intervention and refusal of medical intervention, choosing of a physician and medical organization, information about health condition, information about factors affecting health. Let's consider these rights in more detail. So, the general right to health protection is enshrined in Article 18 of Federal Law number 323. This article proclaims that everyone has the right to health protection, and the right to health protection is ensured by environmental protection, the creation of safe working conditions, favorable working conditions, everyday life, recreation, education, and training of citizens, the production and sale of food of appropriate quality, high-quality, safe, and affordable medicines, as well as the provision of available and high-quality medical care. Thus, one of the fundamental elements of the right to health protection is the right to receive available and high-quality medical care. Availability of medical care is a real opportunity for the population to receive the necessary medical care, regardless of social status, level of well-being, and place of residence. It means free access of the patient to a medical organization, regardless of geographical, economic, social, cultural, organizational, or linguistic barriers. The quality of medical care is a set of characteristics of medical care that reflect the timeliness of medical care, the correctness of the choice of methods of prevention, diagnosis, treatment, and rehabilitation in the provision of medical care, and the degree of achievement of the planned result. Let's analyze these characteristics separately. Timeliness of medical care. In the legislation, the concept of timeliness of medical care is not disclosed, but there are a number of standards that guide the medical organization in terms of the timing of the provision of medical services. If we are talking about the provision of paid medical services, this condition is included in the contract for the provision of paid medical services. And if the term is not specified in the contract with the patient, it must be reasonable. It is stated in Article 314 of the Civil Code of the Russian Federation. In accordance with Part 1 of Article 37 of Federal Law number 323, medical care is organized and provided in accordance with the regulations on the organization of medical care according to the type of medical care, in accordance with the procedures for the provision of medical care, in accordance with clinical recommendations, and in accordance with the standards of medical care, which establish the average duration of treatment depending on the type of medical care, the conditions of medical care, for example, inpatient or outpatient. The correctness of the choice of methods of prevention, diagnosis, treatment, and rehabilitation in the provision of medical care, or the correctness of the choice of method, depends on both the medical worker and the patient. After the patient received the information about the established diagnosis and prognosis of the disease, about the methods of medical care and the risk associated with them, about possible types of medical intervention, its consequences and the results of medical care, and got acquainted with the medical documentation, if he wants, the patient has the right to choose to agree with the proposed methods in the provision of medical care or refuse medical care. This does not apply to cases where medical intervention is allowed without the consent of the patient or his legal representative. This will be discussed below in this lecture. In practice, a situation may arise when a patient does not agree with the method recommended by the physician, and in this case, the physician is obliged to explain to the patient in an accessible form all the possible consequences of such a refusal. Depending on how timely, correctly, and clearly the information is conveyed to the patient, how correctly the choice of method is made, and whether the patient accepts medical care following the physician's recommendations, the degree of achievement of the planned result depends. The degree of achievement of the planned result is the result of providing medical care to a particular patient, taking into account not only the order and standards of medical care, but also the personal characteristics of the patient. And taking into account the timeliness of medical care and the correctness of the choice of the method, one can count on the degree of achievement of the planned results, provided that the patient follow the physician's recommendation, if there is no fault of the patient in not achieving the planned result. At the same time, the achievement of a positive result of treatment also depends on a number of other factors that are independent of either the physician or the patient, such as the individual reaction of the patient's body to a particular medical intervention, the low level of immunity of the patient, for example, during the period of receiving chemotherapy, the neglect of the disease at the time of treatment, or extreme rarity of the atypical nature of the disease, the low degree of knowledge of the disease or complication and the methods of its treatment at the present time, the lack of clear criteria for recognizing similar diseases, etc. Thus, the unfavorable outcome of the disease, like death of the patient or deterioration of his condition or lack of a positive trend, does not always indicate improper medical care. Apparently, this is why the legislator indicates only the degree of achievement of the planned result and not the need to achieve it. In accordance with the Article 10 of Federal Law number 323, the availability and quality of medical care are provided by organization of medical care on the principle of proximity to the place of residence, a place of work or training, availability of the necessary number of medical workers and their level of qualification, possibility of choosing a medical organization and a physician, application of medical care procedures and standards of medical care, provision by medical organization of a guaranteed volume of medical care in accordance with the program of state guarantees of free provision of medical care to citizens. Establishment of requirements for the placement of medical organizations of the state healthcare system and municipal healthcare system and other infrastructural facilities in the field of healthcare based on the needs of the population. Transport accessibility of medical organizations for all groups of population, including the disabled and other groups of the population with limited mobility. Possibility of unhindered and free use by a medical worker of means of communication or vehicles for transporting a patient to the nearest medical organization in case that threatens his life and health. Equipping medical organizations with equipment to provide medical care taking into account the special needs of disabled people and other groups of the population with disabilities, and use of telemedicine technologies. The right to receive free medical care. Article 41 of the Constitution of the Russian Federation proclaims that medical care in state and municipal healthcare institutions is provided to citizens free of charge at the expense of the relevant budget, insurance premiums, and other income. In the development of the provisions enshrined in the Constitution, Part 2 of Article 19 of Federal Law number 323 establishes the right of citizens to medical care in a guaranteed volume provided without charge in accordance with the program of state guarantees of free medical care to citizens, as well as to receive paid medical services and other services, including in accordance with the voluntary medical insurance contract. Article 11 of the Federal Law number 323, which enshrines the principle of inadmissibility of refusal to provide medical care, states that refusal to provide medical care and collection of fees for its provision in accordance with the program of state guarantees of free provision of medical care to citizens are not allowed. Emergency medical care is provided by a medical organization and a medical worker to a citizen immediately and free of charge. Refusal to provide it is not allowed. For violation of these requirements, medical organizations and medical workers are liable in accordance with the legislation of the Russian Federation. Article 80 of Federal Law number 323 states that in accordance with the program of state guarantees of free provision of medical care to citizens, the following types of medical care are provided. Primary medical care, including pre-medical, medical and specialized. Specialized medical care, including high-tech. Emergency medical care, including specialized, and palliative medical care in medical organizations. When providing medical care in accordance with the program of state guarantees of free provision of medical care to citizens, citizens do not have to pay for provision of medical services, the appointment and use of medicines included in the list of vital and essential medicines, for medical devices, blood components, medical nutrition, including specialized medical products, nutrition for medical reasons in accordance with the standards of medical care. For appointment and use of medicines for medical reasons that are not included in the list of vital and essential medicines, in case of their replacement for medical reasons due to individual intolerance, placement of patients in wards, boxes, according to medical or epidemiological indications, for creating conditions, including the provision of a bed and food, with the joint presence of one of the parents, another family member, or other legal representative in a medical organization in inpatient conditions with the child until he reaches the age of 4 years. And when a child is older than the specified age, if there are medical indications. For transport services when accompanied by a medical professional or a patient who is being treated in a hospital in order to comply with the procedures for providing medical care and standards of medical care, if it is necessary to conduct diagnostic tests for such a patient, in the absence of the possibility of their conduct by a medical organization providing medical care to the patient. For transportation and storage in the morgue of biological material received for research, corpses of patients who died in medical or other organizations, and disposal of biological material. The programs of state guarantees of free provision of medical care to citizens establish a list of forms and conditions of medical care, the provision of which is free of charge, a list of diseases and conditions in which medical care is provided free of charge, categories of citizens for whom medical care is provided free of charge, basic compulsory medical insurance program, and average standards of the volume of medical care, average standards of financial costs per unit of medical care, average per capita standards of financing, as well as the procedure and structure of the formation of tariffs for medical care and methods of payment. The program of state guarantees of free provision of medical care to citizens is formed taking into account the procedures for providing medical care and on the basis of medical care standards, as well as taking into account the characteristics of the gender and age composition of the population, the level and structure of mobility of the population of the Russian Federation based on medical statistics. One more important theme which we should mention here is the compulsory medical insurance, CMI. It is an integral part of the state social insurance and provides all citizens of the Russian Federation with equal opportunities to receive medical and medicinal care provided at the expense of the CMI in the amount and on the terms corresponding to the CMI programs. Every citizen who has the CMI medical insurance policy has the right to receive free, timely, high-quality medical care in medical organizations participating in the implementation of CMI programs, regardless of the insurance territory. It should be mentioned that violations of the rights of the citizens to receive free medical care usually are, for example, illegal collection by physicians and secondary medical personnel of medical organizations of fees for the provision of medical care or provision of services established on the program of state guarantees, or illegal collection of fees for the insurance of referrals for treatment or prescriptions for the release of medicines. Illegal purchase of medicines and medical devices from the list of vital medicines and medical devices approved by the territorial program of state guarantees at the expense of patients' fees, or refusal to provide medical care in accordance with the CMI program. In case of violation of the rights of citizens to receive free medical care, a citizen has the right to apply, for example, to the head of the healthcare institution or to an insurance medical organization in insurance cases. If the results of the consideration of his appeal did not satisfy the citizen, he can apply to the relevant health management body under the subordination of the healthcare institution, or to the territorial funds of the compulsory health insurance, or to the territorial bodies of the Federal Service for Supervision of Healthcare. Thus, the right of citizens to free medical care is enshrined in Russia, and a mechanism for the implementation of this right has been created. The main problem faced by residents of the regions of the Russian Federation when seeking medical care at state healthcare institutions is the impossibility of obtaining this free medical care in required amount for free. One of the reasons of this situation is the low level of awareness of patients about their rights to receive free medical care. For example, in healthcare institutions, information stands contain information about licenses, types of free medical care, a list of paid medical services, and information about the schedule of work. But often this information, which is posted on the stands of healthcare institutions and on the internet, is difficult to perceive for patients because it is abundant of difficult terms, for example, which are difficult to understand for patients. For example, when reading a multi-page program of standards of medical care, which is abound in special medical terminology, it is difficult for the patient to figure out whether medical care should be provided free of charge for him. Next right of the patient is the right to choose a physician and a medical organization. It is one of the basic rights of the patient, and it is regulated by paragraph 1 of Part 5 of Article 19 and Article 21 of Federal Law number 323. It should be noted that the law establishes the procedure for choosing a physician and a medical organization only when providing medical care to a citizen in accordance with the program of state guarantees of free medical care to citizens. Because when receiving paid medical care provided in accordance with the civil law contracts for the provision of paid medical services, the patient chooses a clinic and a physician according to the principle of freedom of civil law contract and the voluntariness of its conclusion. Thus, the patient has the right to choose a physician and a medical organization in any case. However, when receiving free medical care, this right is specifically regulated by Article 21 of Federal Law number 323 and a number of bylaws. So, choosing a medical organization. The procedure for choosing a medical organization by a citizen when providing him with free medical care within the territory of the region of the Russian Federation in which the citizen lives was approved by the order of the Minister of Health and Social Development of the Russian Federation dated the 26th of April 2012. And the procedure for choosing a medical organization by a citizen outside the territory of the region of the Russian Federation in which he lives was approved by the order of the Minister of Health of the Russian Federation dated the 21st of December 2012. To receive primary medical care, a citizen chooses a medical organization no more than once a year, except in cases of change of place of residence or registration of the citizen. To choose a medical organization providing medical care, a citizen personally or through his representative applies to the medical organization he has chosen with a written statement on the choice of a medical organization which contains the following information: name and actual address of the medical organization, surname and initials of its head, information about the citizen, his full name, gender, date of birth, place of birth, nationality, data on the identified document of the applicant or his child, place of residence, address for home medical care when a medical worker is called, place of registration, date of registration, and contact information. Also, the following information should be provided: the number of the citizen's CMI policy, the name of the medical insurance organization chosen by the citizen, the name and actual address of the medical organization providing medical care in which the citizen is being serviced at the time of filling the application. After receiving the application, the medical organization performs the following actions. Within 2 working days, the medical organization sends a letter by mail or by means of electronic communication about the confirmation of the information specified in the application to the medical organization in which the citizen is on medical care at the time of filling application. Within 2 working days after confirmation of the information specified in the application, the head of the medical organization that accepted the application informs the citizen or his representative in writing or orally, in person or by mail, telephone, means of electronic communication about acceptance of a citizen for medical care. Within 3 working days after informing the citizen about his acceptance for medical care, the medical organization that accepted the application sends a notification about the acceptance of the citizen for medical care to the medical organization in which the citizen is receiving medical care at the time of filling the application, and to a medical insurance organization chosen by the citizen. And after receiving the above notification, the medical organization in which the citizen is on medical care at the time of filling the application registers the citizen within 3 working days and sends a copy of the citizen's medical documentation certified by the medical organization to the medical organization that accepted the application. And this completes the process of deregistration of the patient from one medical organization and registration him in another medical organization. A citizen cannot be served simultaneously in several regions in the territory of the Russian Federation. And if he submits an application for attachment to any medical organization outside the territory of the region of the Russian Federation in which he lives, he will be forcibly deregistered from the primary place of registration. The choice of a medical organization for the provision of specialized medical care in the planned form is carried out in accordance with the referral for the provision of specialized medical care issued by the attending physician. When issuing this referral, the attending physician is obliged to inform the citizen about the medical organizations in which it is possible to provide medical care, taking into account the waiting time for medical care. Certain categories of citizens make the choice of a medical organization in a special order. Thus, citizens living in closed administrative territorial entities or in territories with physical, chemical, and biological factors dangerous to human health included in the relevant list, as well as employees of organizations included in the list of organizations of certain industries with particularly dangerous working conditions, choose medical organizations in accordance with the decree of the government of the Russian Federation of 26th of July 2012, number 770. And the patient's right to choose a physician is implemented in accordance with Articles 21 and 70 of Federal Law number 323. According to Part 2 of Article 21, in the chosen medical organization, a citizen makes a choice no more than once a year, except in cases of change of a medical organization, of a therapist, a district therapist, a pediatrician, a district pediatrician, a general practitioner, family physician, or a paramedic by submitting applications in person or through a representative addressed to the head of the medical organization. According to Part 1 of Article 70, the attending physician is appointed by the head of a medical organization or division of a medical organization, or is selected by the patient with the consent of the physician. In the case of a patient's request to change the attending physician, the head of a medical organization should act in accordance with the procedure established by the order of the Minister of Health and Social Development of the Russian Federation dated 26th of April 2012, number 407. In accordance with this order, the patient who wants to change the physician applies to the head of the medical organization with a written statement indicating the reasons for changing the attending physician. And in accordance with Article 70, the attending physician, in agreement with the head of the medical organization, has the right to refuse to monitor and treat the patient, except in a number of cases. The choice of a physician and medical organization by military personnel and persons equated by medical provision to military personnel, citizens undergoing alternative civil service, or citizens subject to conscription for military service or sent to alternative civil service, citizens entering military service under contract or equivalent service, as well as detainees, prisoners in custody, or persons serving a sentence in the form of restriction of liberty, arrest, deprivation of liberty, or administrative arrest, is carried out taking into account the specifics of medical care established in Articles 25 and 26 of Federal Law number 323. We will speak about them a little bit later. Also, within the framework of this issue, attention should be paid to the fact that when providing medical care to citizens during practical training of students in professional educational programs of medical education, the patient must be informed about the participation of students in providing him with medical care, and he has the right to refuse the participation of students in providing him with medical care. In this case, the medical organization is obliged to provide such a patient with medical care without the participation of students. So unfortunately, the right to choose a medical organization and a physician is not fully realized everywhere in Russia. And of course, the possibilities of realizing this right for a rural and urban resident are completely different. Highly specialized, expensive medical care is provided in medical institutions located in metropolitan cities, of course, and residents of these cities have more opportunities to choose. Despite the fact that by law, when choosing a physician and a medical organization, a citizen has the right to receive information about a medical organization and about its medical activities, about physicians, about their level of education and qualifications. It is difficult to realize this right due to the lack of a system for informing patients about it. The patient's right to examination, treatment, and maintenance in conditions that meet sanitary and hygienic requirements is enshrined in paragraph 2 of Part 5 of Article 19 of Federal Law number 323. Federal laws on sanitary and epidemiological welfare of the population, on radiation safety of the population, and other sanitary norms and rules regulate accommodation in wards that meet these requirements. The patient should be safe from various kinds of negative consequences of violations of sanitary and hygienic requirements, such as healthcare associated infections, postoperative complications caused by hygiene violations by medical staff, complications after various kinds of manipulations performed with violations of requirements. And the patient should know that such cases are offenses, and that in these cases, the persons who violate the relevant requirements are guilty. Patients need to know that there is a list of requirements for the sanitary and hygienic condition of the clinic and monitoring the implementation of these requirements. This control should be carried out by the sanitary and hygienic service. Next right of the patient is the right to hold a consilium and consultations with other specialists at the request. This right is enshrined in paragraph 3 of Part 5 of Article 19 of Federal Law number 323. Russian patients rarely use this right because few patients know that not only the physician, but also the patient himself can decide that he needs a consilium or a specialist consultation. But this right also has certain limitations. For example, if it is not possible to hold a consilium, then the patient will be denied this right. Refusal to consult a specialist is even more likely, and most likely in rural areas due to the lack of specialists. One of the options for realizing this right is the use of a second opinion. In this case, the patient or his representative takes with him the relevant documents or copies thereof and receives advice and a consultation from another specialist. Next right is the right of the patient to relieve pain associated with the disease or medical intervention by available ways and means. This right is enshrined in paragraph 4 of Part 5 of Article 19 of Federal Law number 323. Medicine considers its primary goals to be the treatment of diseases, preservation and prolongation of life, and the relief of suffering remains only secondary, that is an unprincipled goal. But diseases are accompanied by painful manifestations that prevent a person from living a full life, and acute pains give a person lots of trouble. Therefore, this right of the patient provides for the duty of medical personnel to relieve pain in available ways and means. It is unacceptable to use methods of treatment or diagnosis without proper anesthesia. Next right is the right to receive medical information. It should be said that realization of the patient's right when receiving medical care is impossible without an information component. The patient has the right to receive information about his rights and obligations, and this right is enshrined in paragraph 5 of Part 5 of Article 19 of Federal Law number 323. According to Article 79, a medical organization is obliged to inform citizens about the possibility of receiving medical care according to the program of state guarantees of free medical care, to give patients reliable information about the medical care provided, about the procedure, volume, and conditions for receiving medical care. This information should be provided in an accessible form, including using the internet. The provision of information to the patient is also regulated by the order of the Ministry of Health dated the 12th of November 2021, which is called on approval of the procedure for familiarizing the patient or his legal representative with medical documentation reflecting the patient's state of health. And also in the letter of the Ministry of Health of the Russian Federation, dated the 15th of March 2017, which is called Recommendations on the Provision of Information on the Activities of Medical Organizations, posted on the official websites of state authorities of the regions of the Russian Federation in the field of health protection and medical organizations in the information and telecommunication network Internet. Failure to provide the patient with information entails ignorance about the course of treatment and health status, and violation of the patient's right entails legal sanctions according to Article 237 of the Criminal Code and Article 6.30 of the Code of Administrative Offences. The fundamental basis regulating the patient's right to proper information is Article 22, which is called Information about Health Condition. It should be said that everyone has the right to receive in an accessible form the information available in the medical organization about the state of his health, including information about the results of a medical examination, about the presence of the disease, the established diagnosis and prognosis of the disease, methods of medical care, the risk associated with them, possible types of medical intervention, its consequences, and the result of providing medical care. Information about the patient's health condition is provided to the patient personally by the attending physician or other medical professional who is directly involved in medical examination and treatment. The physician must personally provide such information to the patient in a form accessible to him, except in cases when such information is not provided to the patient, but is provided to his legal representative. In accordance with Part 2 of Article 22, these are situations when the patient is under the age of 15 years, is under the age of 16 years and is suffering from drug addiction, is recognized as incapacitated, or when the patient is under the age of 18 years upon transplantation of human organs and tissues. In addition, if the patient has reached the age of 15 years or 16 years for drug addicts, but has not reached the age of 18, then information about his health is provided both to the patient himself and to his parent, his legal representative. Health information cannot be provided to the patient against his will. And in case of an unfavorable prognosis of the development of the disease, information should be provided in a delicate form to a patient or his spouse or one of his close relatives, children, parents, adopted children or adoptive parents, siblings, grandchildren, grandparents, unless the patient forbade to inform them about it or did not determine another person to whom such information should be provided. The patient or his legal representative, upon a written request, can get acquainted with the medical documentation reflecting the patient's condition of health directly in accordance with the procedure established by the order of the Ministry of Health of the Russian Federation dated the 12th of November 2021. And the patient or his representative gets acquainted with this documentation in a specially designated room of the medical organization. Patients undergoing treatment in the hospital can get acquainted with this documentation directly in the place where they are treated. When providing primary care on an outpatient basis, the patient can get acquainted with these notes during the appointment made by a medical professional. In addition, the patient or his legal representative has the right, upon request, including in electronic form, to receive medical documentation reflecting the patient's condition of health or their copies, and also to receive extracts from them, including in the form of electronic documents, as I said. The procedure of getting these documents is established by the order of the Ministry of Health dated the 31st of July 2020. It should be said that another component of the patient's right to information is the right enshrined in Article 23 of Federal Law number 323, namely the right to receive information about factors affecting health. Citizens have the right to receive reliable and timely information about factors contributing to the preservation of health or having a harmful effect on it, including information about the sanitary and epidemiological well-being of the area of residence, the state of the habitat, rational nutrition standards, the quality and safety of industrial and technical products, food products, goods for personal and household needs, potential hazards to human health of the work performed and services rendered. Such information is provided by state authorities and local self-government bodies in accordance with their powers, as well as organizations in accordance with the procedure provided by the legislation of the Russian Federation. And nowadays, this procedure is established by the order of the Minister of Health, dated the 2nd of December 1999. One more important patient's right is the right to receive medical nutrition if a patient is treated in an inpatient setting. This right is enshrined in paragraph 6 of part 5 of Article 19 of the Federal Law number 323. This right is one of the important rights due to the implementation of which it has become possible to preserve the life and health of some categories of patients. We know that therapeutic nutrition is an integral component of the treatment process and preventive measures, for example. This nutrition includes food rations that have an established chemical composition, energy value, consist of certain products, including specialized medical nutrition products, subjected to appropriate technological processing. Another right of the patient is the right to protection of information constituting a medical secret. This right is enshrined in paragraph 7 of part 5 of Article 19 of Federal Law number 323. The information contained in the medical documentations of the citizen is a medical secrecy, Article 13 of Federal Law number 323. We've already spoken about medical secrecy briefly when we mentioned the principles of medical law. Medical secrecy is information about the fact of a citizen's applying for medical care, about his health condition and diagnosis, and other information obtained during his medical examination and treatment. Disclosure of information constituting a medical secret, including after the death of a person, by persons to whom they became known during training, performance of labor, official, and other duties, is not allowed except in cases established by law. With the written consent of a citizen or his legal representative, it is allowed to disclose information constituting a medical secret to other citizens, including officials, for the purpose of medical examination and treatment of a patient, conducting scientific research, publishing them in scientific publications, using them in the educational process, and for other purposes. Without the permission of the patient or his legal representative, the disclosure of information about him is considered illegal. It is considered to be the disclosure of medical secrecy. In some cases, it is allowed to disclose information constituting a medical secret without the consent of a citizen or his legal representative. According to Article 13, the provision of information constituting a medical secret without the consent of a citizen or his legal representative is allowed for the purpose of conducting a medical examination and treatment of a citizen who, as a result of his condition, is unable to express his will, if medical intervention is necessary for emergency indications to eliminate a threat to human life. Also, it is possible to disclose this information at the threat of the spread of infectious diseases, mass poisoning, and lesions. According to the resolution of the government of the Russian Federation of the 1st of December 2004 on approval of the list of socially significant diseases and the list of diseases that pose a danger to others. These include, for example, human immunodeficiency virus disease, also viral fevers, viral hemorrhagic fevers, helminthiasis, hepatitis B and C, diphtheria, sexually transmitted infections, leprosy, malaria, pediculosis, other infestations, glanders and melioidosis, tuberculosis, cholera, plague, coronavirus infection. Also, it is possible to disclose information at the request of the bodies of inquiry and investigation and the court, at the request of the prosecutor's office, and also at the request of the body of the penal enforcement system. Or in order for the authorized bodies to monitor the fulfillment by persons recognized as drug addicts or consuming narcotic drugs or psychotropic substances of the obligation imposed on them by the court to undergo drug addiction treatment, diagnostics, preventive measures, or medical rehabilitation. It is possible to disclose information in the case of providing medical assistance to a minor to inform one of his parents or other legal representative. Or in order to inform the internal affairs bodies about the admission of a patient in respect to whom there are sufficient grounds to believe that harm to his health was caused as a result of illegal actions. The procedure is established by the order of the Minister of Health of the Russian Federation of 24th of July 2021. Also, in order to inform the internal affairs bodies about the admission of a patient who, for health reasons, age, or other reasons, cannot provide information about his identity. In order to inform the internal affairs bodies about the death of a patient whose identity was not established. Also, the information may be disclosed in order to conduct a military medical examination or in order to investigate an industrial accident and occupational disease, as well as an accident with a student during his stay in an educational organization, and an accident during a person's sports training in an organization that provides sports training, including during his participation in sports competitions. The information may be disclosed when exchanging information by medical organizations, including those posted in medical information systems, for the purpose of providing medical care, taking into account the requirements of the legislation of the Russian Federation on personal data. In order to carry out accounting and control in the compulsory social insurance system, and in order to control the quality and safety of medical services. After the death of a citizen, a disclosure of information constituting a medical secret is allowed to a spouse, close relatives, children, parents, adopted parents, siblings, grandchildren, grandparents, or other persons indicated by a citizen or his legal representative in written consent or in informed voluntary consent to medical intervention at their request, if a citizen or his legal representative did not prohibit the disclosure of this information. And the exception to the general rule of compliance with the regime of medical secrecy is the provision of Article 67. A conclusion on the cause of death and the diagnosis of the disease is issued to a spouse, a close relative, children, parents, adopted parents, siblings, grandchildren, grandparents, and in their absence to other relatives or the legal representative of the deceased, law enforcement agencies and the body carrying out federal state quality control and the safety of medical activities, the body exercising federal control of the quality and conditions of medical care at their request. Persons to whom, according to the law, information constituting a medical secret was provided are subject to disciplinary, civil, or criminal responsibility for its disclosure, taking into account the damage caused to the patient. Another right of the patient is the right to refuse medical intervention. This right is enshrined in the paragraph 8 of Part 5 of Article 19 of Federal Law number 323. There are two types of refusal of treatment, complete and partial. A complete refusal means that the patient refuses to be hospitalized or requires discharge. It means that the patient terminates relations with the medical institution. And in case of a partial refusal, the patient does not agree with some specific physician's proposal, but continues to be treated by him. A patient or one of the parents or another legal representative has the right to refuse medical intervention or demand its termination. The exceptions from this right are given in Part 9 of Article 20, and we will discuss them a little bit later in this lecture when we speak about informed voluntary consent. In case of refusal of medical intervention, the possible consequences should be explained to the patient or his legal representative in the form accessible to him. Refusal of medical intervention with indication of possible consequences is issued by a separate document or entry in the medical documentation and signed by a patient or his legal representative and a medical worker. This procedure is established in the order of the Ministry of Health of the Russian Federation of the 12th of November 2021. If one of the parents or other legal representative of a minor or the legal representative of a person recognized as legally incapacitated refuses medical intervention necessary to save his life, the medical organization has the right to apply to the court to protect the interests of such a person. And the legal representative of a person recognized as legally incapacitated notifies the guardianship authority of the refusal of medical intervention necessary to save the life of such a person no later than the day following the day of this refusal. Another right of the patient is the right to compensation for damage caused to health during the provision of medical care. This right is enshrined in paragraph 9 of Part 5 of Article 19 It is one of the basic rights of the patient, which is enshrined in the current legislation, because the effectiveness of the law is manifested, among other things, through the possibility of compensation for damage caused to goods protected by law. The patient's rights, noted above, would largely remain just an empty declaration, a wish for the medical community and nothing more without this right of the patient. A violation of this right causes harm to protected interests, and this harm must be compensated. The procedure for compensation for harm to the health or life of a citizen, including the patient, is determined by the current legislation. Another right of the patient is the right to admission of a lawyer or legal representative to the patient to protect his rights. This right is enshrined in paragraph 10. And this right allows, in necessary cases, professionally and effectively protect the rights and legitimate interests of the patient. A lawyer may be required by citizen both to solve his current issues, for example, conducting some transactions, negotiating, representation in court, etc., and to defend his rights as the patient. And one more right of the patient is the right to admission of a clergyman to a patient and the provision of conditions for religious rights. This right is enshrined in paragraph 11. This right is a manifestation of the constitutional principle according to which everyone is guaranteed freedom of conscience and freedom of religion. This right is given in Article 28 of the Constitution of the Russian Federation. Some medical organizations nowadays have churches, chapels, and rooms in which you can conduct individual religious rites and meet with representatives of the church, for example. When we speak about rights of the patient, we can't mention informed voluntary consent to medical intervention. Article 20 of Federal Law number 323 states that a necessary precondition for medical intervention is the provision of informed voluntary consent, IVC, of a citizen or his legal representative for medical intervention on the basis of complete information provided by a medical worker in an accessible form about the goals, methods of medical care, the risk associated with them, possible options for medical interventions and their consequences, as well as the expected results of medical care. Consent to medical intervention in respect of persons under the age of 15 or 16 years for drug addicts and citizens recognized as legally incapacitated is given by their representatives, for example, their parents. The order of the Ministry of Health and Social Development of the Russian Federation, dated the 23rd of April 2012, on approval of the list of certain types of medical interventions to which citizens give informed voluntary consent when choosing a physician and medical organization to receive primary health care, approved the list of types of medical interventions requiring consent. According to this order, it is required to obtain written consent for the following types of interventions. Inquiry, including identification of complaints, collection of anamnesis, examination, including palpation, percussion, auscultation, rhinoscopy, pharyngoscopy, indirect laryngoscopy, vaginal examination for women, rectal examination, anthropometric examination, thermometry, tonometry, non-invasive examination of the organs of vision and visual functions, non-invasive examination of the hearing organs and auditory functions, examinations of the functions of the nervous system, like sensory and motor spheres, laboratory methods of examination, including clinical, biochemical, bacteriological, virological, and immunological, functional examination methods, including, for example, daily blood pressure monitoring, spirography, or, for example, cardiotocography for pregnant women. Also, X-ray examination methods, including fluorography for persons over 15 years old, and radiography, ultrasound, Doppler examination, administration of medications as prescribed by a physician, including, for example, intravenously, subcutaneously, intradermally, medical massage, physical therapy. And this list is rather surprising because, on the one hand, a physician without IVC cannot even ask the patient the usual question, what are you complaining about? Because in this case, we are talking about the inquiry, including the identification of complaints and the collection of anamnesis. And on the other hand, this list does not reflect such traditional types of interventions for polyclinic medical organizations, as mammographic, for example, and endoscopic examinations, and the simplest surgical interventions. In addition to this order, the order of the Ministry of Health of the Russian Federation dated the 20th of December 2012 was adopted, approving the procedure for giving informed voluntary consent to medical intervention and refusal of medical intervention in relation to certain types of medical interventions, and also forms of informed voluntary consent to medical interventions and forms of refusal of medical intervention. The order establishes the requirement that when choosing a physician and a medical organization, citizens or their legal representatives must give IVC for medical intervention. The forms of informed consent to medical intervention and refusal of intervention are given in this order. Consent is issued at the first request to a medical organization, and before receiving it, the patient is provided with full information about the goals and methods of medical care, about the associated risk, possible options for medical intervention, its consequences, including the likelihood of complications, the expected results of medical care. Informed voluntary consent for medical intervention is contained in the medical documentation of a citizen, and it is valid for the entire period of primary health care in the selected medical organization. IVC is issued in the form of a paper document signed by a citizen or one of the parents and another legal representative and a medical worker, or it may be issued in the form of an electronic document signed by a citizen or one of the parents or another legal representative, using an enhanced qualified electronic signature or a simple electronic signature by using of a unified identification and authentication system. And also it is signed by a medical worker, also using an enhanced qualified electronic signature. IVC for medical intervention by one of the parents or another legal representative of a person who has not reached the age prescribed by law or is incapacitated can be issued in the form of an electronic document if there is information about his legal representative in medical documentation of the patient. The IVC form approved by order number 1177, which was discussed before, is mandatory for all medical organizations providing primary medical care. However, with respect to interventions that are not included in the list approved by order of the Ministry of Health and Social Development number 390, a separate IVC is required. And along with the IVC form approved by order number 1177, the forms and rules for filling them out approved by the following bylaws are applied. The order of the Federal Medical and Biological Agency of the Russian Federation of 30th of March 2007. This order approved IVC for medical intervention, for anesthetic management of medical intervention, for surgical intervention, including transfusion of blood and its components, IVC for refusal of medical intervention, for vaccination, donor questionnaire, instructions for filling out forms of voluntary informed consent, which are used in federal, state healthcare institutions and clinic of research institutes. Also, it should be mentioned that these forms are regulated by the order of the Minister of Health of the Russian Federation dated the 19th of September 2003 on approval of instructions for the prevention of HIV transmission from mother to child and a form of informed consent for HIV chemoprophylaxis. Also, the order of the Minister of Health of the Russian Federation dated the 7th of April 2016 on the approval of the form of informed voluntary consent for the artificial termination of pregnancy at the request of a woman should be mentioned. The order of the Minister of Health and Social Development of the Russian Federation of the 26th of January 2009 on the recommended form of informed voluntary consent to carry out preventive vaccinations for children or refusal of them. The order of the Ministry of Health dated 31st of the July 2020 on the procedure for the use of assisted reproductive technologies, contraindications and restrictions to their use, and the order of the Ministry of Health dated the 21st of July 2015 on the procedure for giving informed voluntary consent to the provision of medical care within the framework of clinical testing of methods of prevention, diagnosis, treatment and rehabilitation, forms of informed voluntary consent to the provision of medical care within the framework of clinical testing of of methods of prevention, diagnosis, treatment, and rehabilitation, and refusal of medical assistance in the framework of clinical testing of methods of prevention, diagnosis, treatment, and rehabilitation. If the type of medical intervention is not subject to the regulation of the forms of IBC approved by the above orders, execution of a separate IBC is required. Also, we should say that medical intervention without the consent of a citizen or one of the parents, another legal representative, is allowed if medical intervention is necessary for emergency reasons, to eliminate a threat to a person's life, and if his condition does not allow him to express his will, or there are no legal representatives, for example, in relation to minors. In relation to persons suffering from diseases that pose a danger to others, in relation to persons suffering from severe mental disorders, in relation to persons who have committed socially dangerous acts, crimes, when conducting a forensic medical examination or a forensic psychiatric examination, and when providing palliative medical care if a patient's condition does not allow him to express his will and there is no legal representative. The decision on medical intervention, if it is necessary for emergency reasons or in relation to persons suffering from diseases that pose a danger to others, is taken by a concilium of physicians, and if it is impossible to call this concilium, directly by the attending physician or by the court in cases and in accordance with the procedure established by the legislation of the Russian Federation. The decision on medical intervention in relation to persons suffering from severe mental disorders or in relation to persons who have committed socially dangerous acts is taken by the court. And the decision on medical intervention when providing palliative medical care is taken by a medical commission, and if it is impossible to assemble this commission, by a concilium of physicians or directly by the attending physician. Also, we should say that the most common defects in the drawing up of IBC are the following. The absence of an IBC or the use of a form not approved by law, if such a form is approved. Incompleteness of the information provided in the IBC on medical intervention. Defects in filling out IBC, for example, the absence of a signature of a medical worker or signature by an improper subject, relatives of the patient or parents of a child who has reached the age of 15, for example, or the absence of a date for signing the IBC. The absence of justification for the absence of the patient's signature or the execution of such justification is not in full. For example, the absence of a protocol of the concilium on determining the severity of the condition, which does not allow expressing his will, etc. Or placement in the IBC of information not related to medical intervention, like inclusion of paragraphs on the schedule and rules of the treatment and protective regime, on the rights and obligation of the parents of the patients, about familiarization with the standards and procedures of treatment, etc. In order to protect their rights and realize legitimate interests in the field of medicine and healthcare, citizens have the right to create public associations, including public organizations. And Article 28 of the Federal Law on the Fundamentals of Citizens' Health Protection in the Russian Federation provides the right of these public associations to participate in the development of norms and rules in the field of health protection and resolving issues related to violations of such norms and rules. In addition, these organizations can act in court in defense of an indefinite number of patients on the basis of Article 46 of the Federal Law on Consumer Protection. There is also a practice of including representatives of these public associations in the composition of public councils within the bodies authorized in the field of public health protection. For example, the Ivanova Region Health Department has a council of public organizations for the protection of patients' rights, and this council includes representatives of such organizations like Russian Hemophilia Society, Russian Society of the Disabled, the Organization of Nephrological Patients, Nephro League, Center for Assistance to People with Autism Spectrum Disorder, which is called Sadeyствие, and Russian Society of Rare Orphan Diseases, etc. Next thing which we should mention is the rights of various professional and social categories of patients. For example, The Article 24 of the Federal Law number 323 is called the rights of employees engaged in certain types of work to health protection. According to this article, in order to protect health and preserve the ability to work, in order to prevent and timely detect occupational diseases, employees engaged in work with harmful or dangerous production factors undergo mandatory medical examinations. And the list of harmful or hazardous production factors and works during which mandatory preliminary medical examinations are carried out upon admission to work and periodic medical examinations also is given in the order of the Ministry of Labor of Russia and Ministry of Health of Russia, dated the 31st of December 2020. In order to protect health, employers have the right to introduce positions of medical workers into the staff and create divisions that provide medical care to employees of the organization. For example, such divisions as physician's office, health center, medical office, or medical unit, and other divisions. And employers are obliged to provide conditions for employees to undergo medical examinations, as well as freely release employees for their passage. Article 25 of the Federal Law number 323 is called the rights of military personnel, citizens undergoing alternative civil service, citizens subject to conscription for military service or sent to alternative civil service, and citizens entering military service under a contract to health protection. And according to this article, military personnel and citizens undergoing alternative civil service have the right to undergo a military medical examination in order to determine their fitness for military service or equivalent service and for early dismissal from military service or equivalent service on the basis of the conclusion of the medical commission. And citizens subject to conscription for military service or sent to alternative civil service, and citizens entering military service under contract undergo a medical examination and have the right to receive full information about medical contraindications for military service or equivalent service and indications for postponement or exemption from conscription for health reasons. Article 26 of this federal law is called the rights of detained persons taken into custody, serving a sentence of restriction of liberty, arrest, deprivation of liberty, or administrative arrest to receive medical care. So, of course, it should be mentioned that, first of all, these persons have the right to medical care, and hospitals and medical units are organized to provide medical care to convicts, and medical correctional institutions are organized for the maintenance and outpatient treatment of convicts with an open form of tuberculosis, psychiatric diseases, alcohol, and drug addicts. In necessary cases, medical care to convicts may be provided in organizations of the state and municipal healthcare system, as well as by invitation for consultations of specialist physicians of these medical organizations. For example, in emergency cases, it is possible to hospitalize a suddenly ill or injured convict to the nearest hospital. Also, we should mention here Chapter 6 of the Federal Law number 323, which is called Maternal and Child Health, Family and Reproductive Health Issues. Article 51, which is called Family Rights in the Field of Health Protection, proclaims that every citizen has the right for medical reasons to consultations without charge on family planning, the presence of socially significant diseases and diseases that pose a danger to others, on medical and psychological aspects of family and marital relations, as well as medical, genetic, and other consultations and examinations in medical organizations of the state health system in order to prevent possible hereditary and congenital diseases in offsprings. Article 52 is called Rights of Pregnant Women and Mothers in the Field of Health Protection. According to this article, maternity in the Russian Federation is protected and encouraged by the state, and every woman during pregnancy, during childbirth, and after childbirth is provided with medical care. Article 54 is called the rights of minors in the field of health protection, and according to this article, in the field of health protection, minors have the right to pass in medical examinations, provision of medical care, sanitary and hygienic education, training and work in conditions corresponding to their psychological characteristics and state of health, and excluding the impact of adverse factors on them. They have the right to medical consultation without charge when determining professional suitability and obtaining information about the health condition in a form accessible to them. The next group of rights of the patients, which we should mention, is the rights of patients upon the provision of various types of medical care. As we mentioned before, the rights of the patients in specific areas of medicine have significant differences. And these differences are established in legal acts regulating the procedure of providing of a particular type of medical care. For example, in the law of the Russian Federation on transplantation of human organs and or tissues, on psychiatric care and guarantees of citizens' rights in its provision, the federal law on blood donation and its components, on prevention of the spread of the disease caused by the human immune deficiency virus HIV infection in the Russian Federation. And the realization of the patient's rights is a set of measures aimed at the implementation and the embodiment of the right in the actual activities of organizations, government and agencies, officials and citizens. We can distinguish 4 forms of realization of the right. Compliance, it means refraining from commitment prohibited illegal actions. Execution, which means active fulfillment of responsibilities enshrined in the law by performing positive actions. Use, which means exercise by participants of public relations their rights provided in the legal norms. And application, which means organization by the state of the implementation by specific subjects of legal requirements addressed to them. The protection of the patient's rights is a comprehensive system of measures applied in cases when it is not possible to freely realize the patient's rights and when appropriate law enforcement activity on the part of authorized state and public bodies and organizations comes to the aid of the patient's unsatisfied interest. And ensuring the rights of patients is a system of legal means organized in the most consistent way in order to actually realize the rights of patients and overcome obstacles standing in the way of observing their rights. The most noticeable modern trend in this regard is the annual increase in the number of complaints and appeals of patients and the predominance of various means of pre-trial protection of patients' rights, for example, complaints to state bodies and officials over the traditional existing judicial procedures. Of course, the rights of the patient in cases established by laws may be limited. Thus, on the recommendation of the attending physician, certain rights of patients in psychiatric hospitals may be restricted. For example, the right to conduct correspondence without censorship, the right to use the phone or to receive visitors, etc. Patients with infectious forms of tuberculosis who repeatedly violate the sanitary and anti-epidemic regime, as well as deliberately evading examination in order to detect tuberculosis or from tuberculosis treatment, are hospitalized on the basis of court decisions to specialized medical anti-tuberculosis organizations for mandatory examination and treatment. And as we mentioned before in the beginning of our lecture, one of the part of legal status of the patient is responsibilities of citizens. So the main general responsibilities of the citizens in the field of health protection are established in Article 27, Federal Law number 323. And according to this article, citizens are obliged to take care of the preservation of their health, and also in cases provided for by the legislation of the Russian Federation, they are obliged to undergo medical examinations. Also, citizens suffering from diseases that pose a danger to others in cases provided by the legislation of the Russian Federation are obliged to undergo medical examination and treatment, as well as to prevent these diseases. Also, citizens who are on treatment are obliged to comply with the treatment regime, including those defined for the period of their temporary disability, and the rules of patient behavior in medical organizations. These responsibilities of the citizens are regulated in more detail in the legislation regulating certain types of medical activities and by laws adopted on its basis. Thus, only a person who has voluntarily passed a medical examination can be a blood donor, for example. And in accordance with labor legislation, persons under the age of 18 years are subject to mandatory preliminary medical examination at the conclusion of an employment contract. A violation of these responsibilities of the patient is a result in a number of negative legal consequences for citizens. For example, refusal of employment, or refusal of hospitalization or discharge of a patient from a hospital for violation of the regime, reduction in the amount of temporary disability benefits, etc. The duties of patients represent a little studied problem of modern legal provision of healthcare because there are many reasons. For example, the perception of the patient as an initially more vulnerable party in the relationship, in the physician-patient system. Also, one of the reasons is the very nature of the provision of medical care, implying that there is a person who, by virtue of his health condition, has the right to receive medical care, and persons who, by virtue of their profession, must alleviate the suffering of the patient. And one more reason is the constitutional norm declaring that everyone has the right to health protection and medical care. Summarizing the above, we should note that the legal status of a patient in the Russian Federation is determined by the federal law on the fundamentals of citizens' health protection in the Russian Federation, the federal law on compulsory medical insurance, the law of the Russian Federation on consumer protection, as well as current civil legislation. Russian legislation in the field of public health protection has a pronounced social orientation, consisting in giving certain groups of the population additional benefits and guarantees in the provision of medical care. And particular attention is paid to the guarantees of patients' rights in terms of providing them with health information by medical professionals, as well as giving informed voluntary consent to medical intervention. And public associations created by citizens in order to protect their rights and interests in the field of healthcare are entitled to participate in the development of norms and rules in the field of health protection and solving issues related to the violation of such norms and rules.